All right, so welcome to our webinar today on freedom of expression and privacy on social media. Essentially, what we're going to be doing is having the Future of Free Speech's Senior Fellow Joan Barata discussing a paper on the matter, which is currently being drafted. And essentially it's at quite an extended level in terms of substance, but we do want the feedback of our experts and also of our audience. So we will be starting with a discussion of around 12 minutes by Joan on his paper. And then we have the privilege of our experts, Professor Gavin Philipson of the University of Bristol, Oreste Pollicino from Bocconi University, Professor of Constitutional Law, and Giovanni De Gregorio, Professor from Cattolica Global School of Law, who will give a 10-minute commentary on issues that emanate from the paper. And we will also open the floor to questions and comments by the audience. I'm just giving the kind of dynamics and the formalities of the webinar because it's only an hour and a half. Just one request from everyone. I'm going to be keeping time so that we all have, and also I don't want to waste too much time. That's why I'm speaking a little bit quickly. If everyone can keep their time so that we can have a fruitful discussion. And we also have a chat where you can send any questions if you like, and we will be dealing with them. So thank you all for being here this morning, and I give the floor to Joan.
Thank you, Natalie, and I would like to thank all the colleagues who are present this morning, who accepted to engage in this discussion. As already mentioned, this is an effort by Justitia, but also supported by Bocconi University in Milano, to discuss certain issues related to freedom, particularly freedom of expression on social media, and in this particular case about the intersection between freedom of expression and privacy on social media. I'll be focusing on privacy in the broadest sense of privacy, in the sense of the right to, let's say, private family life, not in the sense of data protection. That is an area that is quite a lot analyzed by different scholars, and where we can find several legislation and international standards. But however, when it comes to privacy, freedom of expression on social media, in the sense that I just mentioned, the number of legal standards, international standards, even the case law by, for example, international human rights courts is more limited. And I think that, at this point, what I would like to raise are some conclusions as a result of my recent research, but also some questions and some areas for future research in this area. So I'm going to try now to share my content, which doesn't look as easy as I thought, but let's do it. Can you see my screen? Not yet. You don't see my screen now. Is there, see? Yeah, do you see it now? Yes, good.
Yes, we see it.
Okay, that's a bit, Teams sometimes is a little bit strange. Okay, so well, we know that social media platforms have transformed the dynamics of the exercise of the rights to freedom of expression and freedom of information, but also, particularly from the point of view of the fact that, in the traditional world, so to speak, speech and content was mediated by media organizations that had editorial control over content, but now the distribution of content is intermediated by online platforms, which means something slightly different in terms of absence of editorial control, in terms also of different types of liability. Platforms enjoy intermediary liability exemptions, but at the same time, platforms also moderate content, and those who post content on platforms, of course, they also need to respect the boundaries of the law. This means, that what happens on online media platforms, on platforms intermediated by hosting services, by online platforms, has an impact on freedom of expression, on the formation of the public opinion. That is clear, but it is also clear that we need to now bring to this new territory of online platforms pre-existing discussions on media regulations and self-regulation, including ethical standards, including the use of source, and of course, the respect for privacy and data protection. Here we need to also take into account that traditional media have not disappeared in this context, but moreover, they are using quite often platforms, online platforms, to distribute, to make their content available to a wider audience. But also it is interesting to note that in these online platforms we can find an important amount of new media, journalists, but also the fact that platforms have become an important source of information for all types of media, including traditional and new media. We know that privacy and freedom of expression are fundamental human rights that are protected in Europe, both by the European Convention, but also by the Charter of the EU. Both, are two basic pillars for democratic society, but also for the development and the protection of the human dignity. And also both are subjected to certain possible restrictions according to international and human rights standards. These restrictions, it has to be said that both are articulated through a three-part test, which is also interesting in terms of the similarities between these two rights, but it's also true that in some cases these rights may come in conflict. These conflicts have already been, at least from a theoretical general point of view, have already been addressed in numerous times, for example, by the case law of the European Court of Human Rights, establishing criteria that are based on the idea that freedom of expression, freedom of information prevails in case information is accurate, and also it refers to matters of public interest. In the case of von Hanover versus Germany, number 2, the criteria of, when an information refers to matters of public interest and it's published in a way that this is relevant in terms of the formation of public opinion, have been, let's say, clearly defined in this decision. And at this point, I'm not going to describe it, but just to say that we already have some case law when it comes to the general definition of both rights, freedom of expression and privacy, and the way they interplay and the way certain conflicts between the two rights need to be addressed. However, what is clear is that also with social media, the conflicts between privacy and freedom of expression increase. And this is something that scholars like Dick Burhoff have particularly studied. Now, easier access by citizens to the direct creation and dissemination of content via platforms that, in addition to that, do not exercise editorial control, increases the amount of content that is available and the possibilities to publish. Also, let's say, the distribution of increasing massive number of pieces of user-generated content that reveal at the same time aspects of the private life of the third parties is something that is quite obvious and we see every day on every single platforms. And also the fact that individuals themselves produce and disseminate content that reveals several aspects of their own private life, their personal data, and they share it online, sometimes with an expectation that this will only be seen and commented by their close contact, in other cases with the expectation of reaching out to a wider audience. Also, it's clear that the developments in, let's say, communication technologies in general, the use of smartphones, digital cameras, etc., even makes it easier to, let's say, obtain images, information, particularly unsolicited, let's say, media exposure of aspects of private life, in as much as, again, we are now exposed to different types of devices without us even knowing it. So in this context, I mean, the big question here, I mean, the big debate is, are there private spaces on social media platforms? And here, I believe that we would, in a way, betray the idea of privacy if we wouldn't be able to accept that even in the space of social media, that tends to be quite open and available to everyone, private individuals should be deprived from any expectation to preserve certain information that they share from, let's say, access from third parties in a way that puts them in the open public sphere. I'd say that in the case law, in the general case law about privacy, we find this idea that privacy does not encompass, let's say, the protection of a very limited space, your household, your family, but also protects a certain idea of socialization, the capacity of the individual to develop its own personality through relations, personal, professional relations, to creating a certain social circle that still belongs to, so to speak, a private sphere. So something that we need to analyze is, I mean, to what extent, and I think that we need to claim space for individuals within social media. One, what they do on social media is to share information that is information on private matters, that is information that aims to reach basically a certain limited circle, and it is information that is shared with the expectation that it remains within an intimate circle. Even in cases where this information could go further than that, I think that the expectation of individuals to have a certain degree of control of these information that they share, these expectations need to deserve certain protection from the law. This could also even apply to pieces of information, images of videos posted by public figures on their personal social media accounts. Of course, here, I mean, the limits would be to be drawn in a more strict manner, because there are even some aspects of the private life of public figures that have public relevance, but at the same time, following the case of the European Court of Human Rights, even private figures have the right to preserve a certain private area of their life. Also, this may also include this information that some cases is presented by default when we for example, we Google or try to put a name, and the profile picture or the status emerges even if the rest of the account is protected. And we see, for example, media using these picture profiles, these profile pictures to identify persons that have been the victim of a crime, for example, or involved in some sort of an event. Here also, I mean, an important reflection on the need to protect, in some cases, this type of information, I believe, is relevant. Of course, in this case, also in this area, we need to think of exceptions that would apply to cases where there's an overriding public interest in disclosing information originally disseminating within a private social media environment. Let's think of a public person that, let's say, in the past engaged in activities that were, let's say, published on social media that might affect his future public life, so to speak. So pictures from the past shared on social media that might disqualify him, for example, to occupy a public position. So there are cases where, I mean, there might be an overriding public interest in showing information that has been posted originally as private information. And other exceptions, and I think that this is perhaps the most interesting territory, include the cases where even private individuals deliberately have the intention to reach the general public by expressing ideas and opinions on social media. Of course, in some cases, these individuals might not be fully aware of the consequences that disseminating a certain opinion or a certain piece of content may create, particularly if this becomes viral. And we can think of many examples of the path of this virality of completely individual opinions that were shared at some point using social media. But I think that here, this is also an interesting area to explore. I mean, cases where private individuals do not share information for private purposes, but they share information on social media to have some degree of influence in the public debate. Again, the problem usually comes when this, let's say, dissemination gets out of hand and virality creates a visibility, a sudden visibility of an individual, which is something that this person was not expecting at all. Here, I think that this is also a territory where we can debate and we can further explore, because again, we don't have clear standards or jurisprudence in this field. Final reflection, so far I've been talking about the law, but we also need to understand that platforms have their own internal rules in some cases to preserve as well the privacy and the data of the users. In this context, something that is very important to underscore is that, as I said at the beginning, platforms are in principle not liable for privacy violations that have taken place within their service in cases where this violation of privacy is caused by content posted by a third party. That is one thing. But the other thing, it's true that social media platforms have their own internal terms and conditions that regulate the behavior of users and the interactions between users. And particularly, I think it is very important to underscore the fact that, for example, platforms have policies in the area of privacy that, for example, allow users to control the information that they share and to foresee the use and impact of the shared information. That is, I believe, important. Also, the case in many platforms, we can see, I mean, that they have policies to prevent doxing, which is searching and publishing private information about someone with malicious intent. And this is something that is covered as an unacceptable behavior within the private context of platform policies. And also, I mean, I think that another area, interesting area, is the area of the dissemination of newsworthy events. And here, for example, one example would be whether we all remember that Elon Musk changed the internal rules of Twitter to prevent users from sharing information about the location of his plane. This was in principle protected by internal policies of Twitter, because this might be seen as a matter of public interest where a certain public figure is. But Elon Musk, I mean, deliberately changed the policies in order to prevent this from happening. Or on the other hand, even let's say public figures sharing information, in some cases information that might affect the right of privacy, but these acts by public figures on social media might be particularly protected because they are public figures. They are not individuals using individual accounts for private purposes. So as we can see, going beyond the, let's say, traditional discussions about data protection in the area of online platforms, we see that the old traditional, let's say, issues of privacy in the more traditional meaning of the idea of privacy are also relevant when it comes to the use of online platforms, particularly if we take into account the fact that here we do not only have, let's say, two individuals, let's say the person whose privacy might have been violated and the publisher, but also the intermediary in between that plays also a certain role in all these complex relationships. So this is also something that needs to be considered. So this is I think that I was struggling now with the with my screen. I think that now it's stopped sharing, and this was in a nutshell that the thoughts that I wanted to present, and basically to invite for further discussion and further research on this matter. Thank you very much.
Thank you very much, Joan. I think we'll go immediately to Professor Philipson from the University of Bristol for a discussion on the issues. Okay, thank you.
Thank you, and yeah, thank you very much, Joan, for the opportunity to read your paper, which I found very illuminating. So I'm just going to present a few reflections arising from it. You discussed these kind of scenarios in the paper, and I just want to be clear where I think the broad concern of privacy invasion or privacy concerns, how that can arise on social media. I think first of all, we don't need to worry where an individual simply uploads a given post on Facebook, for example, and then later on changes their minds and delete it. Provided it's within their control, they can simply delete it off the platform. I think the concerns arise in two different scenarios, which I would term the third-party scenario and the data leak scenario. So the third-party scenario is just where information concerning one individual is uploaded by another without their consent. Now, those situations, I think, directly parallel traditional Article 8 claims considered in the Strasbourg case law, which have generally concerned traditional kind of press privacy conflicts. And so that makes the Article 8 case law quite easy to apply in those situations. The slightly more tricky one is what I would term the data leak scenario, where, which I think you're referring to as where a given post might go viral, where a given data subject makes personal data available online and is then reposted without their consent by third parties, perhaps to other sites and perhaps going viral, and A wishes to delete it, which I term, the data leak scenario. And I think here a crucial factor courts will have to look at, which of course you talk about, Joanne, as where the initial posting was to. Was it to a restricted forum, to a small controlled group of Facebook friends, or was it to the world at large, for example, on Twitter? And I think here that the line of Strasbourg case law that starts with Peck and UK can readily be used to support the application of a reasonable expectation of privacy in scenario A, if the data subject could not have reasonably foreseen the extent to which the information will be suddenly exposed to a much wider audience, which will depend in quite large part on the kind of privacy settings they used or didn't use in originally posting it. So I think that's just to set out those scenarios to be clear about what kind of things. I mean, I'm sure there's other ones that people could come up with. Now, in your paper, you largely leave to one side right to be forgotten, which I agree obviously brings in a number of, is a separate and complex legal action. But I would suggest broadly that what we want to see, I think, developing is as harmonized approach as possible between right to be forgotten and Court of Justice approaches to it and the Article 8.10 balance as enunciated by Strasbourg. And so, in other words, we should see right to be forgotten, at least as applied to online speech, as straightforwardly a privacy remedy. And I think the way of doing that is already there, because when applied to speech on social media platforms, Article 17, which is the new right to erasure in the GDPR, should be interpreted in accordance with the rights to privacy and freedom of expression. And the Court of Justice has expressly recognized that in a case called Sinel in 2019, that that the formulation now expressly lays down the requirement to strike a balance between the fundamental right to privacy and freedom of information. And of course, in applying, so in other words, data protection law should be interpreted in accordance with the relevant rights in the Charter of Fundamental Rights, and in turn, the rights to privacy and expression in the Charter should be interpreted compatibly with Articles 8 and 10 of the Strasbourg case law. As the influential Working Party guidance on Google Spain in 2014 said, in determining the balance between data protection rights and freedom of expression, the case law of the European Court of Human Rights is especially relevant. So I think what we would hope to see is a kind of harmonized approach developing between those two courts, which means that member state courts can be applying broadly the same approach, whether the case is brought as a right to erasure or indeed as a more traditional Article 8 kind of tort law claim in domestic law. Now, in relation to your discussion of the von Hanover criteria, which you go through in some detail for balancing freedom of expression and privacy in social media cases, I think they were obviously developed by Strasbourg in more traditional kind of press privacy cases, so it will need some careful thought to kind of apply and develop them to online cases, perhaps especially where they don't involve legacy media. And I think clearly here you're right to say that how users use their privacy settings will be crucial. And I think courts are going to have to start developing some presumptions in relation to that. For example, I would tend to think that material posted on Twitter to the world, as it were, where although you may only have a sort of small amount of followers, you have no control at all about how many times it's reposted or how many people it will reach. I think there should be a presumption that tweets sent in that way to a general audience are not private, although that presumption could be overturned if the material was perhaps very sensitive and the person had very few followers. I think also the subject matter, of course, of the post will be highly relevant, and you discuss this in your paper as well. And here I think we can usefully bring in the fact that both the GDPR and the Strasbourg case law in different ways give special protection to journalism or journalistic material, which recital 153 of the GDPR says should be interpreted broadly to give proper protection to freedom of expression. And indeed, the definition of journalist given by the Council of Europe, quoted with approval in the Strasbourg judgment, Satakunen, is broad indeed, encompassing, quotes, any natural or legal person who was professionally or regularly engaged in the collection and dissemination of information to the public via any means of mass communication. Now, clearly distinguishing that when it's not a professional journalist from just, normal kind of, things that you might post on Twitter or Facebook will be very difficult. But I think the courts are going to have to start grappling with that. David Erdos has argued that the journalist exemption should cover individuals disseminating a message to the collective public, which is very much how you put it in your paper, but it will probably not cover those engaging merely with self-expression and the general freedom to converse. And I think, obviously, as well as the privacy settings, the content of the post itself can help you decide which of those it is. So, for example, if you're posting family pictures or pictures of yourself intended to be seen by your friends and family, that would not be seen clearly as journalism and would be more likely to attract a reasonable expectation of privacy. But if you were, for example, writing comments on law, politics, or current affairs and posting them on Twitter for people to see generally, then that could be seen as something closely akin to or actually falling within journalism and conversely less likely to attract a reasonable expectation of privacy. Third point is that I'm actually rather critical of the kind of balancing test enunciated in von Hanover No. 2 and Axel Springer, although clearly the court has now decided this is what it's always going to use whenever there's an Article 810 conflict. I think the problem that we have is that Article 8, as we know, is very broad, and the Strasbourg court has kind of not defined it exhaustively and been content with making it much broader than perhaps some national courts would have done themselves, for example, in relation to photographs of an anodyne nature taken in a public place. But what we have is two very broad rights, and nearly all the work, therefore, has to be done in the balancing test, which, however, I think is rather vague. And we know that the decisive factor, as Strasbourg said, the decisive factor in balancing the protection of private life against freedom of expression should lie in the contribution that the publication makes to a debate of general interest. But my take on the case law from von Hanover number 2 and Axel Springer is that crucial notion of the public interest has been robbed of many of the coherent boundaries that it would once have had. And that I now think if you actually look at the facts of those cases, you have the notion of public interest expression now seems to include gossip journalism that has some, albeit rather vague, connection to an issue of some legitimate public concern. Courts also very much broadened out the notion of public figure, something else you discuss in the paper, and reported, as we know, on a public figure gains less protection from Article 8 and more from Article 10. That's been dramatically widened from the very narrow approach in the first von Hanover case, in which it was confined to those exercising official functions. And it's been now extended to those who are merely well known to the public. And that's clear from von Hanover and Axel Springer. It's not clear to me why simply being well known because, for example, you're a sporting figure or musician should per se mean that your expectation of privacy is automatically reduced. There may be arguments in particular cases why, but I think that should be dealt with as an aspect of the public interest, not as a kind of generalized reduction in the scope of privacy available to public figures, which I don't think public figures is actually a very helpful concept when you're lumping together things like prime ministers and pop stars in one category. And then finally, Strasbourg has embraced the, to me, very doubtful notion that public figures can lose protection for their Article 8 rights by their own previous decisions to seek the limelight, as it puts it, without really explaining why. And here I think the GDPR makes a much more precise distinction. It says that if the data subject has deliberately made the information in question public by, for example, posting it on a completely public forum, then that may lose their data protection rights over it. That's a very different thing from what Strasbourg has said, which is that your previous conduct, your prior conduct in perhaps seeking publicity or giving interviews to the press might now be taken to mean that you've waived or partially waived your Article 8 rights. And that's something that I hope we may be able to move away from in this area. There doesn't seem any likelihood to me of the Strasbourg court revisiting those criteria. It now uses them all the time. But obviously, they still leave domestic courts quite a wide margin of appreciation in balancing Articles 8 and 10, and the Court of Justice could also take a clearer and more principled approach here, which I hope that it will. Thanks very much.
Thank you very much, Gavin, for your input. And we'll have a further discussion towards the end and also with the participants. So shall we proceed, I think, with Professor Pollicino from Bocconi?
Yeah. Thank you very much. Thank you very much, Natalie, and good morning or good evening wherever you are. And it's for me it's important now, first of all, to thank the organizer, to congratulate Joanna for the very interesting paper, and to try to give you also, a little bit of context, because I think it's important to put this event in the context of what with Professor De Gregorio we are trying to do in the last 6 months, meaning to try to contextualize the right to privacy in a more, let's say, I would say, general and problematic frame. Why? Because we think that as Advocate General Yaskinen was saying in the opinions that Court of Justice didn't follow, as you know very well, in Google Spain, there is a constellation of rights to be taken into consideration. A constellation of rights is exactly what also Joanne is trying to let emerge is in relation to the conflict sometimes the convergence between privacy and freedom of expression. But there is clearly not only freedom of speech involved. No, there is a constellation of rights. By the way, is the codification of rights in the Charter of Fundamental Rights, in which privacy can sometimes meet, sometimes conflict, sometimes be complementary with other freedoms that have the same constitutional standings of privacy. Freedom of speech, it's obvious, but there is also freedom to conduct business on the one end, there is security on the other end. So what is important for us is, from a constitutional law point of view, to try to inject, and Joanne, I think, achieved greatly in this in this exercise to inject in the debate a little bit of the more in relation to the notion of proportionality and balancing, because I think that it's crucial to try to understand which would be the output of the balancing and which are the costs to pay, no, in order to the degree of protection of the right at stake. By the way, as you know very well, balancing proportionality is at the heart of European constitutional law, no? Article 52 of the Charter, but I would say it's a general principle of EU law that becomes enfant terrible in front of the Court of Justice. It's not, unfortunately, my opinion or idea, but it's a quotation of the great book of Takis Tridimas, EU general principle of law. And what I'm trying now to say here is in relation to the specific balancing, the specific, I would say, sometimes conflict, sometimes simply needs to find the right solution between privacy and freedom of speech, starting exactly with the first, I would say, part of the Joan paper that is trying to address a very important, I think, issue. The social media as I would say main engines of the challenge related to the freedom expression in digital context. And what is very important, I think, is that these kinds of, let's say, narrative sometimes can lead to the identification of social media as a public forum, or at least the privileged digital space in which public discourse is framed. And this is, as you know very well, it might be the idea that also coming from the United States Supreme Court, for example, in Buckingham case. So what is very important for us is to try to frame all this debate with European roots. So trying to understand which is, in relation also to Joan's provoking statement, which is the answer of the European constitutional law in relation to this challenge. And what I think is very important in Joan's paper is, first of all, the reference to the European Court of Human Rights, a European Court of Justice case law. Now, what I would distinguish here, in order to add maybe a bit to the reflection of Joan, is to try to distinguish the approach of European Court of Justice, European Court of Human Rights, when the playground is the world of atoms, when the playground is the world of bit. Try to be a little bit more clear. In my view, there is a kind of change of approach whenever the European Court of Human Rights, for example, needs to find the right balancing between freedom of expression and other freedoms, including privacy, in the words of bit. Just to give you an example, freedom of speech, it's obvious that it's considered as I would say, traveling compass, the roadstar of the European Court of Human Rights case law. But this is more clear, in my view, in the context of the words of atoms. For example, handicide, it's obvious, no, that this statement, it's clearly emerging in a very obvious way, no. It's the freedom of speech. It's really one of the most important speech in the European constitutional order. But this is a fear that I have. Maybe I can be wrong. My impression is that when there is a shift from the word of atoms to the words of bits, and Delphi might be a case, you know, there are also other cases that I can quote, but I'm quoting Delphi because it's quoted by Joan in his paper. My impression is that the European Court of Human Rights is a little bit more scared, I would say is scared. There is a kind of digital fear, you can call digital distrust, that basically leads to conclusions that are not always in the line with the previous case law of the European Court of Human Rights in the world of atoms. So what I'm trying to say, that there is a lack of coherence when there is a change of technology. In which terms? Very simply, my impression is that when there is when internet is at stake, and this can be very dangerous if this approach will be confirmed in relation to artificial intelligence, in relation to the new technologies. When internet is at stake, the European Court of Human Rights is considering less, I would say, rigorously, less strictly, less, I would say, in a less protecting way the freedom of speech. Delphi is just an example. As I said, I can bring other examples, but my impression is that there is a march for member states much broader in these cases, no? To give justifications. And this, I think, it's a trend that we should, in a way, take into account, and in a way also share what Joan knows very well, the worrying statements of, at the time, Justice Shah, you know, that in his dissenting opinion, his Delphi said this kind of trend can lead to self-censorship. So this is something that has to do also with the balancing between privacy and freedom of speech, because as you know very well, this is again are not my words, privacy is the European First Amendment. So there is a kind of very important, I would say, temptation from European courts to basically enforce in a unilateral way digital privacy, and the sacrifice might be very high, not only for freedom of speech, especially for freedom of speech in this case. And then I will, and this will be my second point, Google Spain, that is again a case that is quoted and very well analyzed in the Joan paper. I mean, Google Spain, it's very well known to have a kind of, again, unilateral approach, meaning it doesn't consider, in my view, the broader constellation, but it's focusing for good reasons. I don't know if they are good, but maybe understandable reason at that time, meaning a kind of European reaction to the global surveillance from an external point of view, and the waiting for Godot, where Godot is GDPR, from an internal point of view. I mean, these two challenges basically, I think, provoked the court that basically started to dress, to wear the hat, and not only the hat of the legislators. But what I'm trying to say now is that after GDPR, after that legislator have shown the possibility to act sometimes also in a hypertrophic way, as we know, the impression should be that now, and maybe the CNIL case, it's a good example, because you will remember that according to the Court of Justice in the Google Spain 2, let's say, the first ideal scenario would be a global removal in terms of the removal of the indexing. But what the court is leading is a more reasonable conclusion, saying the first ideal scenario would be a global removal, but we do not, I'm saying with my words, this is not a quotation, we do not want to engage in a judicial colonization. Bruxelles effects, if it should be an effect, should come from legislator, not from judge. It's a kind of self-restraint in order to defer to other constitutional values of other states in other parts of the world that simply do not share the same European constitutional humus. So in my view, this should be the approach. This should be the approach in terms of self-restraint that would really, and this would be my last point, in terms of trying to find an equilibrium between being a model for example, privacy protection and being exported. And on the other hand, to avoid to be a European fortress that is very strong inside, but it totally lacks the interconnecting bridge in order to have, first of all, a good enforcement. Secondly, to have a language that might be understood also by other parts from a geopolitical point of view. And my last footnote will be the following. DSA is trying to, I think, to row in this direction because it's not imposing, let's say, new substantive obligation to gatekeepers, no, in my view, but it's imposing new procedural obligations. Basically, it's a kind of due data process that is helping exactly to try to speak this common language that might be understood also from European, from the United States interlocutors, that they know very well the due process as a doctrine. So my last point would be the following. Let's try to follow this kind of direction in when we approach the problem of balancing. On the one hand, to not betray the constitutional traditions, the European constitutional traditions. No, this is very important. Otherwise, the risk is really to not take into consideration the European context in which this balancing, no, is basically achieved. On the other hand, to not be slave of the European constitutional tradition. I don't know if I'm clear. On the one hand, to be coherent. On the other hand, to be able also to look beyond in order to find the bridge, for example, transatlantic bridge. And this transatlantic bridge should be developed not only and not especially by judicial bodies, but I would say by political bodies, because simply the judicial activism in these fields will lead to an amplification of fragmentation, of jeopardization, at the end will harm legal certainty that is crucial in general and especially in the digital market. Thank you.
Thank you very much for that intervention. And I think we'll quickly move to Professor De Gregorio from Cattolica Global School of Law for his comments.
Thank you so much. Thank you so much. I hope you can hear me. Of course, it's a pleasure to see you all. And of course, let me also join the other speakers and also Rexa to say that we are pleased to be here within the framework of this conversation on balancing, and is also a nice opportunity, I would say, also to focus on the balancing with the free speech and privacy that are actually two of the fundamental rights, or usually the two constitutional interests that often we see clashing when we focus on digital spaces. And I'm using the plural because we have multiple ways, multiple areas. It's not just about social media, it's also about other places where we exercise this freedom, and both freedoms, let's say. And of course, the moments, let's say, the times when these two freedoms clash to each other are very, very much relevant, especially, you know, when it comes to all the technology we are using, especially in the last years, you know, from new systems of generative AI, new applications, social media. So these things are expanding and are expanding faster and are just amplifying the questions related to the balancing between some of the rights that we know very well, also because courts have already addressed the balancing of this right, also because there have been other, you know, also doctrinal research, there have been research and also conversation, also policymakers with the new adoption of legislation from political advertising to the DSA. This is, of course, shows the discussion about how it is important to balance and the role of freedom of expression, of course, even in the digital age. So, I mean, this is quite clear. This kind of common framework that moves from courts to policymakers to research. So there is a very, very high attention on how we can strike a fair balance between the two things. And of course, as has been already said, I mean, this question is not a unique answer. Whenever we move from different constitutional systems, the answer we get probably sometimes of this balancing is slightly different, even if we are supposed that constitutional democracies tend to protect freedom of expression in an equal way. But this does not mean that freedom of expression is seen on the same position. This has been said already said, and this is the starting point when we talk about the balancing between rights, and especially free speech and privacy, when we look, for example, at social media space, if we want to use this example, precisely because the paper of Joan actually focused on this space. And what is interesting is also, I mean, that of course there have been already cases that have been mentioned again, where we have seen in these online spaces so how to strike out how the balancing between free speech and privacy works, but this sometimes is not enough. Because nowadays, I mean, especially because this has also been mentioned, the DSA has also, in a certain sense, it will shape this balancing between free speech, not only privacy, but also other constitutional rights. Because even when we comes, for example, to an important provision of the DSA, for example, when it requires, for example, online platforms to take into account the charter when enforcing in their terms of services, this is quite important in terms of balancing, because whenever it happens, whenever it comes to decisions, for example, of moderation, of decision making by social media, in this case by online platform, generally speaking, the problem is that it is important also to see how this balancing happens, not only, and this is also been stressed by Joan, the idea of these private spaces, also happens when it comes to social media. So it's not just about how courts strike fundamental rights and the balancing, but also how social media contribute to this role. And this is very important because the DSA actually introduced this system that was quite implicit before the adoption of the DSA, because in a certain sense also the Commerce Directive, at least in the European framework, but even the Communication Decency Act in the US, indirectly, and even the Communication Decency Act even directly say to all hosting service provider or to computer service provider, actually gives them the freedom to make decisions on what to do with content, of course, even to remove content, okay? And the DSA actually now at another point in the balance, because it's not just enough to provide like exercise a kind of discretion in making these decisions, but it's also about balancing. It requires actually an activity of balancing between whether something should be removed, should be blocked, should be demoted, demonetized, and whatever, against, for example, because in case of the conflict with another constitutional right, with a legitimate interest, so with, generally speaking, with the charter. And so this changes a lot the way in which we think about also the balancing, because the DSA actually introduced a certain place where actually stress that this balancing should happen. It should also happen ex ante before a court comes in and say, oh, this balancing is unfair, is disproportionate, is not based on a legal basis. But this actually looks actually at social media as a first place for this balancing between free speech and privacy, for example, in this case. And this is fundamental when we address the question of balancing between in the digital age. We have already seen examples like when we think about the Meta Oversight Board, for example, where the balancing and the idea of human rights in terms of services have moved far beyond, let's say, not far beyond to say that it's far, but just say outside the framework of courts, as we mentioned, courts actually balancing rights and freedoms. And so all these pieces of the puzzle tell us a story actually where we are increasingly seeing, the question again of balancing involving the private sector. This, of course, it's important on the one end, but it's also dangerous on the other end, because on the one end, it's important because it recognizes the important role that these actors play, of course, and also for the users and for the community on social media, it tells that there is an important role of thinking about these rights together, not just to focus on free speech or not just to focus just on privacy. It's important just to strike a fair balance. This is an important thing to stress because of the roots, especially of the European constitution, but we mentioned also why balancing is not that important, because if we grant protection to just one right, we tend to lose the protection to the other right. And the question is why, if both rights are protected by the charter, and both rights can be limited, like the case of free speech and privacy, as you know very well. But also this could be not dangerous, but it could be challenging also for social media as private actors, because whenever they are, of course, entrusted, they are being recognized with such a role. This also requires, like developing a bureaucracy, decision making in order to make it, and also show accountability. And this also can not only affect the balancing between free speech and privacy, but it can also affect the balancing with economic freedoms. It can lead to the question of Delphi, because if we put too much, work on a private actor, this could lead to collateral censorship with all the problems actually that have been already mentioned in the case law, also the European Court of Human Rights. But in generally speaking, it's interesting to observe, apart from the problems that have been already stressed, it's interesting to see again how this balancing exercise has increasingly been recognized to these spaces. And this is also, in a certain sense, it's a double sword as usual. It's beneficial because it helps to have this balancing rather than thinking about that one right could prevail over the other, or this balancing should not be done at all, generally speaking, you know. So it's important that there is that now the balancing is at the core. But balancing means not only thinking about the for example, how we can combine, in a certain sense, if you want, the need to protect speech with identity, with privacy, and so forth. Thinking about the recent case also with the deep fake of the interview with Germany, this has been actually shows the balance between, if you want, privacy and free speech in digital age, and who actually makes the decision on that. Of course, we cannot just wait court sometimes because it takes so long, especially now that a video can be created by an automated system and can be spread so fast. So there is definitely an important role of whoever it is, whether it's social media, whether it's a generative application system, to actually understand ex ante how to make this work. And so the balancing moves not only from the individual conflicting rights at stake, like privacy and free speech, for example, in one case, but also needs to take into account from a regulatory point of view how also businesses will be able, or the private sector, because at the end it's the private sector implementing these things, this form of balancing, how actually this is sustainable in the long run. And this is the another important point in question about the role of balancing. And of course, and this opens the door towards not only preempting regulation, banning regulation, or banning these applications, because we should not look at the poles, exactly because the balancing is actually at the center of the discussion. And this leads also to more, let's say, discussion, conversation, constructive conversation between policymakers, for example, in this case, in social media or whatever kind of service it deals with the balancing in the digital age. And this conversation sometimes is more institutionalized when we look at process, for example, of co-regulation, when we see actually there is more conversation and we come together, for example, with code of conduct, code of practice, instruments, guidelines, actually that puts together the needs exactly to balance different conflicting also interests. And this is an important example showing how the balancing has moved in a certain sense, but as actually had already moved, but generally speaking has moved from the realm of courts, as has been said, to a more generalized space that is made by private actors, is made by policymakers, even ex post, because nowadays the balancing of policymakers does not happen only ex ante when they assess actually the rights that could be interfered by a regulation, but it comes also ex post, because now we see implementing acts, we see guidelines, we see a lot of instruments that actually shapes the balancing and guide the balancing after the adoption of the regulation. This raises a lot of questions on how, even after the adoption of the regulation, the role of policymakers also in conversation with the private sector shapes this balancing, even ex post. So the ex post phase is not just for courts, but it's also for all the actors involved in this conversation, including courts for sure. And so this is just, in a certain sense, to also to interact with the paper by Joanne and to understand how this process of balancing is changing in the digital age, and this actually is more, I mean, it's more cooperative, but more cooperation needs also more organization and structures for sure. Thank you so much.
Thank you very much for your intervention. Maybe now we can have a final kind of commentary amongst our experts. Joanne, do you want to make some final comments?
Thank you. But first of all, thanks for all the comments, because I mean they are very interesting and extremely useful. So I thank you all for your remarks. I mean there will be many things I could comment on, but I just picked 2 or 3 of them. First, on the right to be forgotten, I agree that here the right to be forgotten is something different, but at the same time it's something relevant as part of this discussion. But it is something very special as well. I mean, in the sense that in the right to be forgotten, the structure of the right to be forgotten basically, I mean, puts a platform in the position of assessing a possible violation of the right to privacy data protection of a user without listening to the speaker, to the actual speaker, to the creator of the content. And in some contexts, it is even not possible for the platform to contact the original creator of the content to make a proper assessment between the two rights at stake. The other thing is that also beyond the individual assessment made by or the first assessment made by the platform, then the institution that intervenes is a data protection authority. So, which is probably biased when it comes to making a certain balance between privacy and freedom of expression. So, I mean, from a structural point of view, also the right to be forgotten has many issues probably, I mean, in terms of freedom of expression, is not the best possible approach. But I understand that it is also challenging. By the way, I think that the Garante, the Italian Garante, yesterday issued a document where I could read between the lines some sort of an approach to a new formulation of the right to be forgotten within the context of artificial intelligence and the way that Chat GPT was using data. But the second thing is that I wanted to talk about a little bit is about what was mentioned about the relevance of the behavior of individuals when posting content on social media platforms. And one could say, well, you had the possibility of hiding or limiting the access to your account. But probably we also need to take into account that in some cases, a lack of literacy or awareness might have to be taken into account. Well, many social media users are not aware of, I mean, the impact that their posts may have. They may have an expectation that these may only be seen by their contacts, but as a matter of fact, it's seen by everyone. So here, I mean, there's something that judges may have to struggle with, and also something that we need to take into account, as Gavin pointed out, is the fact that basically it depends on the social media platform. Also, I mean, the kind of approach that you may have. When you post something on Twitter, perhaps the intention, the expectation is something different from when you post something on Facebook related to your private life, or LinkedIn, and when it comes to your professional life, so on and so forth. And here the big question mark is whether the judiciary is prepared to understand all these contextual elements that go beyond the things that the judiciary has traditionally taken into account in this kind of conflicts when trying to address this kind of conflicts. I would also like to, because I think it is very important what Orestes said about the world of atoms versus the world of bits, and this would take us a bit far from the topic, but I think it is very important to stress this fact. We see that particularly outside the European Union, with all these cybercrime laws that are being adopted in many jurisdictions in the world, where, I mean, basically there's an overriding concern about safety of the net, the security, the impact that speech may have. And now, these days in Vienna, we have these discussions about the new UN cybercrime treaty, where, I mean, the position of certain states was to emphasize security and certain national interests vis-a-vis freedom of expression and the protect of all the right online. So I think that this is a very important discussion. And when it comes to the DSA, that has also been mentioned by Giovanni, I think that it is very important, the fact that the DSA indeed includes now references certain obligations for online platforms to protect human rights. It is not clear how these can be articulated. I mean, whether it is, let's say, a positive obligation or a negative obligation, in the sense that, I mean, whatever you do, at least you need to make sure that you don't violate, or you need to actively protect privacy. This is not clear. I mean, the sense of, for example, Article 14 of the DSA. But something that I think it is also very important is the fact that possible violations of human rights also constitute systemic risks that platforms need to assess according to Article 26, and also platforms need to adopt mitigation measures to kind of prevent these violations of human rights. privacy can be in that mix, of course. And then, of course, we will have regulators, national regulators, and the European Commission, in the case of very large online platforms, of course, trying to assess whether the mitigation measures adopted by platforms to prevent violation of human rights are correct or not. No? So by the way of what Giovanni was saying, this new kind of approaches and this new kind of way of seeing the protection of human rights beyond the courts and by other mechanisms, I think that the DSA, when it comes to the risk assessment, let's say, mechanisms and the risk mitigation measures, I think that will trigger questions also in the field of privacy. But these are quick comments because otherwise I would take most of the time. But again, thank you for your remarks.
Thank you very much, John. Professor Philipson, Gavin, some final comments?
Yeah, just very quickly. I mean, yes, I suppose, Joanne, you sound pessimistic that courts can grapple with things like privacy settings. I mean, I would just hope that People's Counsel would energetically explain these things to the court and draw it to their attention. But I agree with you that it can only be. I was talking about presumptions, I think, which courts could use to try and structure their reasoning a little bit. But I agree. I see cases of people posting horrifically personal things about their mental state and illness on Twitter without much thought. And maybe they would bitterly regret those things, but by that time they've been retweeted. And I think that there certainly can be instances in which the presumption of posting something publicly means that you don't have a reasonable expectation of privacy in relation to it can be overridden. Just on Arresta, the only thing I would say is it strikes me that the arguments about whether Google Spain was an example of judicial activism are kind of belong to the past, because we've now for many years had Article 17, which clearly instantiates an extended right to be forgotten. I think we should be concentrating on how that should be interpreted and applied, and how far we can ensure that that's a harmonized approach with the approach to Strasbourg to Articles 8 and 10, although accepting, as Joanne said, that the context is a little bit different, and many of the decisions will obviously in the first instance be made by private platforms, as Giovanni was stressing, with then review perhaps by national data protection authorities, and ultimately the courts only as a backstop and only coming in a very few cases. But I would hope that judicial guidance will be taken clearly on board by DPAs and indeed the platforms in making these in assessing right to be forgotten requests. Thank you.
Thank you very much. Oreste, maybe some comments?
Thank you. Yes, very short comment. I think that what is important to understand in order to let's say identify the right boundaries, also in terms of separation of powers between judicial bodies and political and legislative bodies, is the difference between substantive values and procedural obligation. What Gavin was saying is true. I mean, we are clear in our Article 17, but at that time, there was not Article 17. And what the court did, it was, in my view, to apply horizontally. This can do that the European courts, they cannot do the American courts because they have the state action doctrine, to apply horizontally Article 7 and 8. They did in a very hidden way. But if you think about, they basically enforce such rights against a private operator. Now, my point was, what about procedural safeguard? Not about new substantive right, because there are no doubts that there is a very good new right, the right to be forgotten, right to be de-indexed. But what a little bit troubles me in that judgment is that we're missing the procedural safeguards in order to understand we should be the procedural steps in order to empower the user vis-a-vis the private operator. And this is exactly, I think, is not in relation to right to be forgotten, but in relation to this new season of digital constitution that I call procedural season. DSA, it's a good example because it's trying to focus more on procedural obligation that on the one hand, they will not provoke, in my view, I hope, some self-censorship spillover effects. On the other hand, will empower user by, trying to enforce what I call due data process. You can call fair trial. You just can have in mind Article 6 of European Convention of Human Rights, a change geometry from a vertical dimension to a horizontal one. I think this is a good trend because in a way it's a good compromise. It's a language that is not only European, because due process, it's thanks God, very well known by United States constitutional law. Thank you.
Thank you very much. Some final comments by Giovanni.
Yeah, thanks. Very, very brief. I would just say that this picture again it shows us that the need, when we think balancing nowadays, especially with all these actors involved, the balancing is not just, again, this is the message at least, is not just related to courts that have played a critical role to show that there is a balancing need also in the digital age, but also requires more coordination and also structure, a little bit more of thinking about how we can coordinate this activity among not only the relationship between courts and lawmakers as constitutional courts, sometimes it happens, but also when it comes to users, when it comes to platforms, when it comes to online media platforms, of course, when it comes to civil society participating, when it comes to lawmaker, ex ante and ex post. So this all requires coordination, also to avoid exactly then there are, in a certain sense, fragmented approach, as we have seen with data protection authorities or national authorities. So also at the top level with European institutions. And so all this relationship requires more coordination. So in order to strike what we usually tend to call a fair balance. Thank you.
Okay, so I'm not sure if we have any comments or questions from our participants. Maybe you could include them in the chat. If not, Joanne, how shall we? Sarah Fisher. Hang on.
Perhaps we can give her the floor so that she can.
Yes. Would that be okay? Søren, can you help me on that to give the? Oh yeah, no, that's fine. Sarah, would you like to intervene? If you unmute the phone.
Did you have a question in the chat now or a comment in the chat from Sarah Fisher?
Yeah. Hi, Sarah.
Hi, I hope you can hear me. My question was just, so it seems like a user's ability to reasonably foresee the reach of their social media post would seem to depend at least partly on what they know about or what they might know about the platform's amplification algorithms. And there's been, I guess, various calls for platforms to be more transparent and open about what those are. And if that's right, could there be a kind of dynamic effect on their privacy and their right to privacy, as you've been discussing? So, yeah, I hope that's clear.
Thank you, Sarah. So who would like to start? Anyone? I leave it to you.
No, just say thank you. No, thank you for the question. And I think that, well, the DSA basically, I mean, now introduces obligations for platforms in the areas that you have just mentioned. What would be interesting, perhaps, would be to see whether for a judge, the fact that the DSA becomes applicable and now the DSA has these obligations vis-a-vis users is used to say that now users cannot claim anymore that they don't know or they are not aware, because this obligation now is clearly established in the DSA. But again, I think very clearly that this gives us another reason, if you wish, or another area presents another area where transparency becomes very relevant, and a reason why. I mean, the platform, let's say, obligations of transparency are also relevant when it comes in connection to the protection of the right to privacy.
I mean, just to add on that, I think, yes, there's clearly a relevant role there for transparency on amplification algorithms. I mean, in relation to harmful content, as opposed to privacy invading content, Mark Zuckerberg has said that policies to what he calls demote or make less visible posts, as opposed to the more drastic step of deleting them, can actually be almost as effective in preventing them reaching a wide audience. And there may be a role there for posts. I don't know whether that could possibly work. But platforms themselves to make less visible posts that clearly implicate the user's privacy. That would especially be if they've been reposted without their consent, but I suppose could in theory apply even if they've inadvertently revealed personal details, so have kind of self-doxed themselves, as it were. But certainly, yes, the more users know about these kinds of policies, the more empowered they are in managing their own privacy on social media.
Giovanni or Esther, any other comments on Sarah's intervent? No? Giovanni?
No, I think it's a very important question, and probably we have not enough time to address that question, because this also requires a lot of conversation about also how to balance the process of content moderation, especially when there is an increasing demand from users in terms of understanding what's going on, but also protecting and understanding sometimes some of what they see. It depends actually on their preferences, and this, of course, so sometimes it's a paradox, because this call for more transparency comes from it could be the price to pay for this transparency could be more to disclose also the preferences coming from getting this information. So, and this is it's a balance that probably would require more coordination as well.
Okay, thank you, Giovanni. Do we have any other comments or questions in the chat? I don't think so. Okay. All right, Jean, shall we wrap up? Yeah. Okay, so thank you everyone for being here today for this fruitful discussion. And Joanne, maybe a couple of words about the paper and how you're going to integrate the input and proceed with Bocconi, because some of the participants may be interested in that.
Yeah, hopefully, yeah. After this discussion, we hope that we have triggered some interest in the topic. I'm planning to kind of to incorporate all the different comments into the paper, so that it can be released soon. So we will be using both Bocconi's and ECtHR's platform to kind of disseminate the paper and continue perhaps this discussion in a different format. But yeah, we are hoping to publish some sort of a final deliverable soon. And my understanding also is that this recording will also be made public. Perhaps this is something that we need to internally agree on, but this would be something that I would propose. But yeah, stay tuned, because I believe that very soon we'll be disseminating both the video of this event for those who couldn't attend it, and also some sort of a final version of the paper.
Okay, perfect. Thank you so much. And we'll be, is there another comment, or I think, no? Okay.
No, I was just adding another thought to Sarah in response to Sarah's question.
That's quite interesting, though. Do you just want to mention it? Maybe because the chat, if people are on the phone, maybe they can't see the chat.
Yeah, I was just saying, yes, of course, there can be more complex algorithmic issues that go to how visible a post becomes, but there are certain quite fundamental differences. If you've got a relatively contained group of friends on Facebook, for example, and you post something on that you know who it goes to, as opposed to I do think there's a presumption that a tweet that you put that is available to anyone in the world who uses Twitter, that prima facie at least, that doesn't attract a reasonable expectation of privacy, though I think that should be, a rebuttable presumption. But those differences, and I would hope most users would be aware, but clearly education of people on privacy settings is key to enable them to manage their own privacy, which is ideally what we want, rather than, regulators and courts having to become involved. That should only happen when something's gone wrong. Right. Yeah. Okay. So thank you. And also on behalf of ECtHR and the Future Free Speech Project, the collaboration with Bocconi is just a great platform to develop this, and to all our experts and participants. And we will keep in touch and see you soon. Thank you.